Do you know your options if you are injured while at work? We've all heard about workers' compensation, but what does it mean exactly, and how should you go about filing for it? Well, Catherine Stone from Injury Florida Law is back with us with some advice. Definitely our workers' comp go-to lady. Welcome back.
Thank
How
you.
you doing?
So great to be back.
You know what? Let's take it, since it is a new year, let's take us back, because you've had reminders, several times of things you want people to know when it comes to workers' compensation. Where do you begin? Kick us off.
I think you begin with the accident, and I think you begin with the reporting requirement, because if you fail to meet that reporting requirement, you're not going to have a case. Okay. And a lot of times I get phone calls. I had one this morning where someone had called me about a 2023 claim, and fortunately they are still within their statute of limitations, but they did not properly file or notify their employer of the incident. So it's going to be very difficult to meet that reporting requirement. So there is a 30-day from the date of the accident reporting requirement, or 30 days from when your doctor tells you that it's work-related. So for instance, carpal tunnel, a lot of times people won't know why their hands or wrist hurt from, maybe a lot of typing all day, or, whatever they're doing with their hands. And they might just be going to the doctor complaining that their hands hurt or their wrist hurt, what's going on. The doctor may order some testing, may get a little more familiar with your job duties, and then ultimately come to the conclusion that this should be covered by workers' comp, because it's called what we call repetitive trauma. So repetitive activities can sometimes lead to certain injuries. So it's 30 days from the day the doctor tells you that it's work-related, or it's 30 days from, you slipped and fell.
A big injury.
A big injury. You slipped and fell on coffee in the break room, or you tripped on a cord and fell over at the computer or the copy room, whatever it may be. It's 30 days from when you knew or should have known that you had an accident. There should be a report that your employer, so you have to notify your employer, and you can't just notify your coworker.
That does not count.
It's got to be somebody that's in a managerial or a supervisory role. Human resources that can fill out or submit a work comp report of injury. And there's actually a report of injury on the state's website, the Florida Department of Finance's Workers' Comp Division. There's actually a report of injury that you yourself can print off, fill out, and submit.
Okay.
I also have one on my website that you can pull off, print, and submit to your employer if your employer refuses to provide you one.
Okay.
There's ways that we know who the insurance company is. If your employer is uncooperative, because sometimes I get a lot of phone calls where the employers are not wanting to accept that report of injury for whatever reason, which they have their own reporting requirement to the state. They are supposed to submit that report of injury to the state within 7 days of receipt of that report of injury.
So they've got their own time frame. What do you tell people then as we get ready to share your contact information in closing? If that time frame has already passed, do they still go ahead and reach out to you?
You can still go ahead and reach out to me. There may be ways that we can get around that, or there may be things you haven't thought of that the supervisor saw you fall. Okay, so
you'll be able to navigate those waters. That's what we've learned from Catherine Stone over the course of her time here. We want to again share the information, injuryfloridalawfirm.com.